to get into the room. Madison, can you let me know when you think we've got most everybody?
Yes, sir. You should be good.
We should be good. All right. Well, good evening, everyone. Welcome. Appreciate everybody taking the time out of their busy days to meet with us for a little bit. My name is Jacob Runyon. I'm the head of the litigation department here at Smith Kline Smith, and look forward to getting to know each one of you this evening and throughout the life cycle of your case. I've got Charlie Kirby with me today, and she'll introduce herself here in a little bit and tell you a little bit about her department and what she does. And I've also got Nikki with me, and she will kind of take part in the presentation today as we go through the life cycle of a case. So let me share my screen. All right, hopefully everybody can see that all right. So certainly each one of you have felt, some form of broken trust from the various types of facilities that you or your loved one was at, experienced some loss and uncertainty as a result of the negligence of the facility, and you've made the decision to file a lawsuit and try to get some justice for yourself or your loved one. So we know that this decision is certainly not something that's easy. It takes a lot of energy, certainly from you and your family to be able to bring this case, and we're here to help guide you through that process. So the life cycle of a case, we've kind of got it split into kind of four areas as it moves through. So the first is intake and investigation. Nikki will be kind of addressing you, kind of letting you know what that looks like, where we gather information. You tell us your loved one's story. We'll then move on to medical and pre-litigation. Again, Nikki will kind of walk you through that, gathering the information, getting the medical records, having our expert kind of review the case to determine whether it's meritorious enough to be able to file in court. Moving on to litigation, and I will kind of walk you through that, through actually filing the case, the discovery, mediation, settlement, and all the way up through trial. And then probate and administration. Most of these cases all have to have probate, and I'll talk about that for briefly a minute. And then I'll turn the time over to Charlie to kind of tell you about the administration of the case, dealing with liens and getting settlement, distribution, and dismissal of the case. So we've got a few various team members, kind of got some caricatures of various staff here. So Bianca will be, hopefully most of you have talked with her, kind of getting your case signed up and beginning of the investigation of the case. Medical pre-lit, that's going to be Nikki, and then myself. And then Lori heads up kind of overseeing the probate department, and then Charlie with administration. So I'll turn the time over to Nikki and let her kind of take you through pre-litigation.
Thanks, Jacob. So by the time the case comes to pre-litigation, most of you will have spoken to either Bianca or Erica, and they would have gotten some details from you, a little bit of information regarding the case and what happened to your loved one or to yourself if you're bringing the case for yourself, enough for Bianca to determine that, yes, this is potentially a case that we can look into. During the pre-lit phase of the case, we meet with you and the case managers who have been assigned to your cases, and we'll have a video call with you. We do a video call because we like to see you. I'm sure you'd like to, at least meet the people that you're speaking to, put a face behind the voice that's on the phone whenever you call the office. And during that intake, we get a little bit more information and a little bit more detail about what happened to you or your loved one. And during that call as well, the case manager will find out some family information We get family information because unfortunately, most folks who are in nursing homes do not survive their injuries, and we have to make sure that we have the right person bringing forth the case on behalf of the estate of your loved one. So our case managers will be asking you questions about family, about potential heirs. If the injured party and your loved one is still alive and they are not able to bring the case for themselves, we want to find out whether you have the authority to bring the case by way of a power of attorney, guardianship documents, etc. So we do that as part of our family memo investigation. We also do some research behind the scenes into the facilities in which your loved one was resident and where they were injured. So we'll take a look to see who owned the facility, who operated the facility, who was in control of management, in control of making sure that this facility had enough nurses, etc. And at this point, we also get the litigation team involved. And you'll find that even though your case is in pre-lit or at one particular stage, there is a lot of interaction and collaboration between the departments. So in terms of making sure that we have the right defendants later on for your case, we get litigation involved right at the very beginning of pre-lit to make sure that we've got detailed investigation and research into the corporations. As part of pre-lit and the medical aspect of your case, we of course need to request medical records as well as billing records. We request medical records along with getting affidavits of business records affidavits for the providers to verify that those are a complete set of records. Often, I know that most of you will have some medical records of your loved ones or for yourselves if you're the injured party. We do want to receive those. If you do have them, great. We would love to get those and actually get a jump start on the case and to be able to take a look into the case. Because, you know, like we say, with regards to pre-litigation, everything involves investigating the claims, and not that we do not believe you, but investigating whether we have breaches in the standard of care and whether this is something that an expert, which I'll talk about a little bit later on, will be able to back. So if you've got some medical records, it's always great if you're able to send them over to us in order for us to begin some sort of preliminary review. Once we get all medical records in, we have our nurses, and we do have some nurses who work for us, who put together a nursing chronology, as well as look at what the nursing staff in the facilities did wrong. And so we have nurses put together a report along with what they believe are breaches in the standard of care. We also take a look at the reports ourselves. So not to say that we just rely on the nurses, we take a look at the nurses' reports as well and go through them as well as the medical records thoroughly. Once we've got that done, of course, with most of these cases, and I know Jacob will speak to this in terms of the litigation, experts are required. And there are some states where before we can even send the case on to the litigation team and get the case filed with the court, we need to get an expert to sign off on the case and to essentially rubber stamp it and say, yes, this is a case that has merit to file in. And yes, there are breaches in the standard of care, and those breaches in the standard of care caused the injuries that we are complaining about. So we do get that done as part of our expert review, as part of our medical and pre-litigation stage of the case as well. If your loved one was covered by Medicare or Medicaid, we do have to set up a lien and a date of injury. It has to be supplied to our admin department. And I'll let Charlie speak to that a little bit later when we get to her stage of the PowerPoint. But we do assist in providing a date of injury as well as a diagnosis in order for our admin department to go ahead and pull those liens that need to be paid back at the end of the case. And that's essentially it. You'll be hearing from one of your case managers if you have not already heard from them, in order to get intake scheduled, and every 30 days to give you an update on your case. And that's it from me. Thanks, Jacob.
Awesome. Well, appreciate it, Nikki. So after kind of Nikki's department, Nikki gives us the green light to get the case filed. It's going to move to litigation. So litigation means that the case is actually filed in the court. So I know sometimes people they hear the term litigation and they just think that that means that that is a trial. Litigation means the entire time we're in the court system is litigation. So the start of the case is going to be the lawsuit actually being filed. Depending on the state that you are in, it's either going to be called a complaint or a petition. And that's the document that basically says what they did wrong with the allegations and puts the defendants on notice of what we're complaining of. After it is filed with the court, defendants then receive notice that is called either a summons or a citation. So they get that with a copy of the complaint, and sometimes, depending on the state, an affidavit of merit or various expert reports showing that the case does have merit. The defendants then will have an opportunity to challenge the pleadings. So sometimes the case can be held up in the trial court for sometimes many months as the defendants file motions to dismiss or demurs, challenging various aspects of the pleadings, claiming that there's some deficiency. As soon as we get kind of through that, the defendants will then file an answer on the case. And they have approximately about 30 days, really depends on the jurisdiction, but it's about 30 days, kind of by and large throughout all the jurisdictions, to file an answer to the complaint. After they answer, we'll then move on to the discovery period. Now, discovery is the longest part of the litigation process. It can typically last anywhere from 9 to 18 months as we are conducting written discovery. That is where we exchange written questions, requests for production that ask for tangible documents. So we're exchanging emails and photographs and medical records and staffing data and written policies and procedures, and getting all the information that we're going to need to be able to prove this case to a judge and a jury. We'll also take depositions. Depositions are basically interviews that are taken under oath with a court reporter. We'll have kind of motion practice, and then eventually we will have to designate an expert or experts on your case to be able to prove it in a court of law. So we have various experts that Nikki coordinates with, various doctors, nurses, administrators of facilities that we use to be able to prove our case. And again, that kind of goes into the interplay between all of our departments. We really work together as a team effort to be able to get this. So please don't ever feel like you're necessarily being passed from one person to the other. We're all kind of working together to make sure that your case is a success here at the firm. Eventually, we're all kind of leading up to mediation. Mediation is where basically you hire a neutral third party to come in and attempt to get some resolution for the case. Most of these cases will end with mediation, but some will not be able to be successful at mediation, and we will have to try them. And that's what most everybody's going to typically think of with a jury of your peers to be able to decide the negligence of the facility. So that's kind of the longest part of the litigation. Again, this part is going to take anywhere from 12 to 18 months, and sometimes longer, just depending on what happens on the case. If things get appealed on the case, facilities declare bankruptcy, there's lots of different things that can happen that can extend the time period past that, which will lead us into probate. Probate will kind of begin at the very beginning of your case and kind of carry throughout, kind of depending on the facts and circumstances of the case. So if the injured person is still living, then we don't have to do probate. Probate is only necessary for people that are deceased. And when people are deceased, to be able to bring a survival action for them, that's that individual's pain and suffering, mental anguish, their medical expenses that were incurred as a result of the injury. we have to get probate done to be able to have authority to be able to pursue the claim and also to be able to get liens and various things throughout the case. So in the probate process, Lori or other members of the staff will be in contact with you. We will do kind of a family investigation. Sometimes just be prepared. We've got to ask sometimes difficult questions that people don't necessarily want to talk about, but it's necessary for us to know those things so that we can figure out probate. Like they're going to be asking, criminal history, whether somebody has ever been convicted of a felony. We're not doing that to be intrusive. We're doing that because the courts require that. Because a lot of jurisdictions that would prohibit somebody from being the administrator of an estate. So we got to know that so we can come up with a contingency, hopefully, to be able to get around that. If somebody has a will, then we deal with that in probate, naming the executor or executrix of the estate. The probate department will also work with family agreements in various situations. Getting the probate petition, there's various witnesses that have to be called, lots of forms that have to be filled out, and we have to get court approval that basically gets at the very end of probate. All I'm worried about in litigation is getting letters of administration or letters testamentary, which grant that individual the permission, the ability to be able to pursue those survival actions of the injured party in court. And that will lead us up to the most important person at the firm, Charlie Kirby. So turn the time over to Charlie. You're muted, Charlie.
My name is Charlie. I am part of the administration team here at the firm. You will sometimes talk to us at the first of your case and sometimes at the end of your case, definitely. We will be contacting you about any forms that we need signed for authority, any death certificates that we may need to retrieve if that's applicable. Any correspondence that you may get from Medicare or Medicaid. We may ask you some of those questions, but what we do in our department is handle your liens and subrogations. Medicare and Medicaid have the right to retrieve back what they've paid out for your injury during the course. And we look into that. We get those subrogations in, we go through those dates, make sure they all apply, to the injury, and then we get those reduced when your case settles. With that, we may need some authority to help do that with probate. We get the information that we need for your injuries and the date of the injury from Nikki during the investigation of your case to set that up. So we may be in contact with you about those things. You also may get correspondence from Medicare and Medicaid. That's nothing you have to do with anything. You can just put it in a little folder, just keep it, during the duration of your case. We may request it, but normally we get the same copies as you do, but you don't have to answer any questions. You don't have to send anything back. We handle all of that for you. When your case settles, a person from my team will also be contacting you and introducing themselves and let you know that we'll be contacting you with a settlement release for signature with or without a notarization, whatever it requires. And then we will send that off to opposing counsel to get those settlement funds in. We also are responsible for any case cost that may attribute to your case. You will have filing fees, medical record charges, expert cost. We keep up with all of those for you in an itemization so that at the end of the case, those are recouped from the settlement amount. You do have the right to ask for those at any time. We can send those to you. We can keep you posted on how much those have actually incurred during your case if you like. If not, you will be provided an itemized at the time of your settlement. I have several people on my team. They're fluid throughout the department, so they all may contact you at different times. But like Jacob said, everyone in the firm sometimes touches a case and works on a case. So if you have a different person call you or you have a different email from someone, that's just different parts of our team reaching out for things that we need to progress your case and get it moving and keep it moving. So that we can expedite these things as soon as possible for you. We understand that you want closure and you want to put this behind you, but yet you want some accountability and some justice for this. But we try to not to bug you if we don't have to. We know this is a hard situation to deal with and we understand. So we try not to prod you all the time about it. but we are here to answer any questions if you need us. At any time, you can call the firm and someone can always answer your questions.
Awesome. Well, appreciate it, Charlie. So, big thing that I want everybody to take away, that this truly is a partnership with you, and you are vital to the success of this case. So please make sure to tell us as much information as you think that you know that will be important to making sure this case is successful. If you have questions, ideas, please let us know. Please stay in touch. Frequently I know people can be rather mobile these days and move, get new phone numbers, new addresses, new emails. So if you change any of those, please contact us and let us know. Because sometimes on these cases, things can change rather quickly. And sometimes we might need to get a hold of you quickly to be able to make a decision. So it's important that we can get a hold of you quickly, that we can make a decision. Make sure to keep important documents. If you have videos, if there was a nanny cam or something that you've got footage, you've got pictures on old cell phones and you're about ready to trade in your phone, please make sure that you save and retain those emails, text messages, journal entries, because those will be needed in the course of litigating the case. And we just can't do this without you. You have certain information that will be important to this case. Make sure to stay connected. Got various ways and various websites to social media to stay in touch with us. So please make sure to take some of this information down and stay in touch with us and keep up to date in various advances in our fight to change how nursing homes and various facilities are running and operating, because our goal is to try to help minimize the amount of abuse that's occurring out there in this particular area of the law. And one last slide here, just with our telephone number and our website. So if you don't have that, please take that down. With that, that's all we have for this evening. We will be happy to stick around a little bit if anybody has any questions. There is a Q&A button down at the bottom. Feel free to type in a question and we will answer as best we can. But if you don't have any questions, feel free to take off, and we look forward to working with each one of you in the success of your case.
Jacob, you want to answer that one?
Yeah, so the first one is how do I know what stage I'm in? So part of that, if you have not had your intake with Nikki's department yet, then I can probably assure you probably are still in kind of the pre-lit investigative part of the case. Once you move to litigation, you will be notified. We send out a text. We will send out an email welcoming you to the litigation department, and we'll have a discovery questionnaire for you to fill out. So if you haven't received any of those, I can assure you, you're still in the pre-litigation department. And I got Nikki kind of nodding her head here, and she can look up to, and she'll get with you and kind of give you an idea of kind of where and when they might be in contact with you in the coming weeks. Next question is, how can I get a copy of the PowerPoint? Yes, I believe Madison will get a copy of this out to you, and you're welcome to have it. Can we use the app to send documents? Yes. So we've got it's called Case Status. And through Case Status, there's an application that you can download on your phone. And through the application, you can upload and send us documents. And, feel free. You can also send us documents, via email. But the Case Status app will allow you to be able to send stuff that's larger than can typically be sent in a email. Let's see here. Any other questions? Did I get them all? Give everybody 20 more seconds if you've got any questions. Do we continue to send pictures and medical records to the same email? So if you're in pre-litigation, yes, you're welcome to continue to send those to your pre-lit manager of the case. If your case has moved on to litigation, I would ask that you try to send it, if you know who your paralegal is and the attorney that's assigned to your case, to try to send it to them. But if you're not sure, feel free to send it to whoever's email you have, and we'll make sure that it gets to the right place. All right. Well, I think that's it. So again, appreciate everybody's time. If you have any questions, please reach out to Nikki, Charlie, or myself, and we'll be happy to point you in the right direction. Again, look forward to working with each one of you, and we'll talk to you later. Have a good evening.